All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in the case of East Valley Fiduciary Services, Inc. versus IASIS Healthcare Holdings, Inc. et al. Our civil number 12-0469. Each side will have 20 minutes within which to present their arguments. This morning, appellants may reserve some portion of that time for rebuttal. We leave that up to you and the management of time in that decision. We have read the briefs. We've reviewed the record. We've conferenced the case. We're familiar with the issues raised and the underlying facts that you've that relate to those issues. So please keep that in mind as you make your arguments here today. We are recording these proceedings, both with respect to audio and digital video. And at some point, hopefully within the next day or so, the video will be available for those who are interested in watching it. But as you approach the podium, please identify yourself and your clients so that we can accurately keep track of that. And with that, Mr. Greisen.
Good morning. I'm Elliot Greisen. I'm appearing today for the appellant, Karen Savageau, who was represented by East Valley, who was appointed as a conservator in the trial court below. At the close of the defense case, appellant Karen Savageau filed a motion for a judgment as a matter of law. I'd like to talk about that first. The standard for review of that judgment is well established in Arizona. It is the same as the standard to apply to a summary judgment motion. Plaintiff, appellant Karen Savageau, presented Dr. Berlin. There's no dispute that he was qualified to testify as to the standard of care for hospital administration. There's no dispute that adequate foundation was laid for his expert testimony on the standard of care for hospital administration. And there's no dispute that he testified directly on the point, beyond a reasonable degree of medical probability, to near certainty he testified to, that defendant Mountain Vista, IASIS, violated the applicable standard of care when they lost an MRI and did not detect that they had lost it and failed to get a report back to the treating ER doc. Neither was there any dispute that if the ER doc had received the correct, proper report in a timely fashion, that he wouldn't have sent appellant Karen Savageau home. He would have admitted her, neurosurgically gotten a consult to drain the abscess, keep her in the hospital, high-dose antibiotics, and that's how the outcome would have changed. Defendants. Mountain Vista essentially presented no evidence. Beyond that, they admit in their brief at page 31 that they didn't have to present any evidence. And they really had to admit that because they didn't present any.
But they did cross-examine the doctor?
Yes, sir, they did. Let me address that just for a second. Their cross-examination, during the cross-examination, Dr. Berlin never contradicted himself, never changed his opinion that the violation of the standard of care occurred. They asked him questions about the primary thrust of their argument, sir, is that they asked him questions about the documentation that was in the record. And the problem with that is, because the hospital had just opened up, the hospital was lacking in documentation. Let me just give you one example. If an individual at the hospital would send the MRI off to the Nighthawk reading service, he or she would make a little note, sent off MRI at this time, what the study was. At the other end, the Nighthawk service would make a note when they sent it back. The ER personnel would have notes as to when it came back and that it was given to the doctor, and the doctor would have notes that would document the fail-safe mechanism that Dr. Berlin applied. And Mr. Checkett, for the defendant Mountain Vista, did cross-examine him. The questions that he asked, of course, are not evidence, and Dr. Berlin never contradicted himself.
But did he not make statements on cross that, from which it could have been inferred that the basis for his opinion that the hospital had done something wrong was because the result was wrong?
The result was wrong because after analyzing what happened, reviewing all of the depositions, reviewing what happened in the medical records, and commenting on the lack of documentation, the fact that the result was wrong and that this was not picked up is simply a substantial part of his opinion.
Right, and I certainly not, I'm not suggesting that there's something wrong with that notion. I mean, it's a very common sense notion. Something went wrong, let's look to see what caused it. But the defendants want to make of that he was basically admitting that all he was presenting as an expert was a common sense lay opinion, essentially.
In the setting of his testimony, Judge, his testimony was not common sense lay opinion. It was based upon his professional background. And what he testified to was the documentation was so poor. In fact, I think we put it in our brief that the president of the Nighthawk service got on the stand, and his testimony was he couldn't figure out what happened because the documentation was so poor. So I think I would answer that question by saying he never contradicted his original opinion, which that was a violation of the hospital administration standard of care. The prima facie case was never affected. He had to admit that in some places he didn't know exactly what happened. For example, the training. We knew that they retrained all of the personnel to fix a problem, but there was no documentation as to what they trained him on, and no documentation as what had to be retrained. So that stood. And on the other side, no expert testimony on an issue that a lay jury can't understand, no evidence or facts to establish a genuine issue of a material fact. And that's the weighing that the trial court has had to do, and that's the weighing that I'm asking you to do, to apply the standard of care for summary judgment to a situation where one side has a qualified expert testifying with absolute assured opinions, and the other side has nothing. The second issue. Although there's three issues really presented, they all involve methamphetamine. Long before trial, appellants recognized that if the methamphetamine evidence got into trial, all of it got in. The trial would become a trial of whether Karen Savageau was a bad person, whether methamphetamine was a bad drug, and whether she deserved everything she got. So before trial, we filed two motions in limine, both of them addressing methamphetamine use, both of them addressing different time zones. One before the visit to Mountain Vista, and one after the visit to Mountain Vista. Again, the standard to apply, I believe, is well-established Arizona Rule of Evidence 403. In weighing that, the trial court, and I would ask you to decide, in weighing that, you have to weigh the probative value against the prejudice. And the probative value, in order for it to get in, has to substantially outweigh the prejudice. It is hard to imagine any testimony and evidence that would be more prejudiced against my client than what got in. Essentially, everything got in.
You concede, though, Mr. Greisen, that the evidence of the history and evidence of use was relevant to issues of both causation and damages.
Judge, I would say that issue, some of it was very marginally relevant, very marginally. And I proposed before trial, let's let in that she used methamphetamine intravenously before the visit in that immediate 6-week period of time, and let that get in so they understand the mechanism and causation in the injury. That was not allowed. Instead, the floodgates opened up. Everything got in. Everything got in. The trial court set the rules. I had to live by them. And throughout the trial, I did my very best to live by them, and I believe I did. But I would concede, Judge, that there was very little evidence. Say on the life expectancy issue. The life expectancy issue could have been handled in 2 or 3 questions. The experts on the stand. Dr. X, have you reviewed the medical records? Yes. Do you have an opinion as to, based on the medical records, Karen Savageau has a reduced life expectancy? Yes. Is it to a reasonable degree of medical probability? Yes. What is it? It was reduced 5 years. That would have been it.
Well, that would have been it for the
direct
examination.
Yes, that would have been for the direct examination. But we could have kept, the floodgates were opened up. And I think we documented very well in the record, witness after witness, 282 times. All of the jury questions were not related, well, there were a couple, but of the 100+ jury questions, the majority were related to methamphetamine, IV use, drug use, what a bad person she was, before and after this occurred. We did the best we could. The case was complicated by the fact that our causation expert, our standard of care expert, our nurse, was allowed to testify in causation and nothing was done about it. I filed a motion for judgment in a matter of law, asking for a very strict instruction from the judge to tell the jury that he had considered the evidence and they should disregard this evidence, the part that she contributed to the injury that occurred. The end result, if you look at the totality of the trial, was it turned into a drug abuse trial. And the end result was that Karen was denied a fair trial. Karen was denied her opportunity to come in the trial court and present the evidence in her medical malpractice case. Unless you have other questions, I'm going to reserve the balance of my time.
Thank you, Mr. Greisen.
Thank you.
All right. Appellees.
Good morning, Your Honors. My name is Kevin Meyer from the firm Renault Cook, Drury, and Massaros, representing the quantum appellees. Between the appellees, we've decided to try to allot our time as follows. I'm going to handle the second and fourth issues, which address the methamphetamine use, and Mr. Checkett, my colleague who represents Mountain Vista, will address the first and third issues regarding the standard of care and the nursing expert. If there were 203 instances of improper references to methamphetamine use or drug use or any of the other permutations in plaintiff's argument, there were 203 opportunities to object. There were 203 opportunities to ask for a sidebar. There were 203 opportunities to ask for a curing instruction. There were 203 opportunities to ask for a mistrial. There were a number of instances in which this could have been preserved on appeal, and the plaintiff could have identified how the case was going differently than what he thought might be under the ground rules he described. That doesn't happen.
Mr. Meyer, don't you think plaintiffs preserved that issue by their multiple motions in limine?
Absolutely not. Let me explain why. The first motion in limine is actually titled Motion in Limine to Preclude Drug Use Other Than Intravenous Methamphetamine Use. It's talking about the cocaine. It's talking about marijuana. That motion was uncontested. This was not a case about the evil drug user. This is a case about what happens to your body when you use methamphetamines for 20 to 30 years, sometimes to a day. And that comes from the answering brief. That's from her own admission of her history to Dr. Proudfoot on admission. All the methamphetamine use is relevant to a multiple of aspects. It's relevant to causation. It's relevant to mitigation of damages. It's relevant to life expectancy. When plaintiff's own expert, Dr. Blackwood, says he can't tell whether the symptoms she's complaining of as a result of the delayed diagnosis, because this is a medical negligence case, and that's the alleged medical negligence, is the delayed diagnosis. When Dr. Blackwood says he can't tell whether the symptoms she's complaining of are due to the delayed diagnosis or due to this meth use, that's relevant. When Dr. Lobat says that he didn't know anyone who had used meth for 20 and 30 years and was still living, again, that's plaintiff's own expert. That's relevant to all the aspects of this case. Plaintiff, we need to talk a couple of things about this. Sorry, Judge Thompson.
It's been conceded that there's relevance, but I want to make clear what you said before. You're saying that there was no motion in limine to preclude evidence about methamphetamine use?
I appreciate the chance to clarify. The motion in limine number 1 was really more about other drug use. This is Instrument 84. And if you go there, what they're talking about is cocaine and marijuana and the other drugs she used. Motion in limine number 12 comes along, and that's the second motion they talk about. But that's really just trying to preclude methamphetamine use prior to her admission to Mountain Vista on August 12, 2007. So there's really never a time in which plaintiff is making this comprehensive case to say meth is bad, meth is prejudicial, all references to meth should be kept out. That just hasn't happened. And again, I would submit that even if there was something like that, and that had been objected to, a motion in limine had been made in that fashion, and it had been denied, I would still say that plaintiff has a duty and obligation to show throughout the trial how this is changing and how this is evolving, and to warn the court this is exactly what I warned you would happen pre-trial.
So this point is different from your assertion earlier that the plaintiff waived the issue. Now you're making the point that even if the motion was made and denied in an order that stated general parameters, it's the plaintiff's burden to, during trial, aggressively enforce those, whatever they may be.
Yes, it is. I believe it is, Your Honor. I submit, first of all, that the scope of the motions that were submitted are actually not as broad as plaintiff is suggesting. But that even if they were, there still is a duty we have to give the trial court a chance to correct these issues. And a plaintiff can't sit back and, I mean, for a plaintiff to suggest to this court that the motion, that the entire trial was lost in 2002, before, a year before trial ever took place, based on the motion in limine rulings. I submit that this court can't let litigants get away with that. There is a duty to bring this to the court's attention. We should also talk about the fact about these numbers, because if plaintiff says that 282 references to methamphetamines were used, it's only 85 and 62 references to meth that are part of that 203 number. So that's 147. That means the plaintiff brought it up just as much as defense counsel did.
Wasn't that, I suspect Mr. Greisen would say that was to counter the cross-examination that was being done by defense counsel.
Absolutely, Your Honor. I mean, of course, there's the idea of drawing the sting, and that's something that every litigant would do. But if you look at the witnesses, plaintiff brings up the issue of meth indirect with every single witness. It's early on, it's in the beginning, and we talk about the idea that a witness might say meth 4 times in one sentence, and that doesn't mean that it's 4 times as bad. It's just being discussed. But I mean, Dr. Proudfoot had to talk about meth because that was one of the issues. You know, did she present in a situation that made it seem like she was on meth? And if she seemed like she was on meth, isn't that a reason to have held her regardless of what the MRI results said? Talked about it with Nurse Zimmerman, and Mr. Check is going to read a passage from you in a second here, where there was a sidebar in which Mr. Greisen admits methamphetamine use is relevant to every single aspect of this case. It can't be excised. And what's really interesting is there really isn't this argument of how this could have been excised. Plaintiff, appellate counsel stood up here today and said, this is how we could have done it with the life care plan. And I think the simple question is, then why didn't you do that? There is no effort by the plaintiff in this record to try to protect against these things. And really what we're talking about is not a reference to meth, because meth is relevant and it's admissible. All of the doctors talk about meth. You have to be able to distinguish between how those symptoms affect the neurology or how they affected the damages. And everyone did talk about them. They talked about it on direct, they talked about it on cross, they talked about it in redirect. It was relevant in every case. The only thing that's really a problem is if the stigma of meth is somehow used. And I submit that appellant counsel has not shown you any instance in which either defense counsel was arguing that she's a bad person, don't give her money because of it. In fact, one of the instances that they complain about, this is in footnote 139 on page 44 of the opening brief. It's the 6th entry. One of the times they fault us for mentioning meth, the statement was this. Okay, last couple of things. And it kind of follows up on this. The fact that she had been using meth, she's entitled to the same care from the hospital, doctors, everybody as everybody else, correct? So we're apparently being faulted for saying the word meth when we're making the exact argument that plaintiff wants us to make. Let me talk really quickly about the curative instruction. There was an instruction. It was given. I know plaintiff says on page 16 of the opening brief it wasn't. In pages 40 to 43 of an answering brief, we detail how plaintiff was given 3 separate opportunities by the trial court, 3 separate reminders. I need an instruction. I need an instruction. At the end, when the instructions are being finalized, plaintiff's counsel says, well, where's my instruction? And the court says, it's right there. I based it on a case you were giving me in chambers. Here's the instruction. Let's read it together. Plaintiff reads it. Now, at that point in time, Rule 51 requires the plaintiff to do 2 things. First, he has to specifically identify why that instruction is insufficient and proffer a wholly new, ready-to-go instruction. Plaintiff never does that. The reason the objections are so important is because what plaintiff is really trying to argue here is that, yeah, all of this was kind of admissible, but it created this overall bad feeling. And there was sort of this kind of ghost in the room that she was a bad user. Prejudice has to be affirmative on the record. The only real way that he could have preserved that error was by moving for a motion for new trial. Now, I'm not suggesting that a motion for new trial is required to preserve every error. But an error like this, when you're talking about how it affected the jury, when you're talking about something that's not going to show up in the record, only the trial judge is in a position to have looked at the witnesses, looked at the jury, tried to see what that effect had, and that person is lived with the case. I mean, this court has talked often about the cold, dead record. There's just no way to preserve that error unless you make a motion for new trial. And those are the enumerated grounds in 59 talk about irregularity in the proceedings, irregularity in the conduct of the closing argument. That error should have been preserved. It wasn't. But again, it would just be a claim of error. There was no error in this case. Methamphetamine use was relevant in this case because of the way it affected the symptoms, the way it explained all of the symptoms. This is a case of medical negligence, and so the plaintiff has to prove that it's more probable than not that it was the delay in diagnosis that caused the symptoms she complained about, things such as cognitive dissonance, or cognitive impairment, I should say, neuropathy, vascular constriction. Those could just as easily have been explained by the methamphetamine use, and because they could, this means plaintiff failed her burden of causation, and that's why it was relevant.
All right, counsel, are you addressing the issue with Dr. Berlin, or is Mr. Checkett?
Mr. Checkett is.
All right.
Unless the court has any further questions, I'll cede the balance of my time to my colleague, Mr. Checkett.
Good morning. May it please the court and counsel. My name is John Checkett. I represent the hospital in the case, which is Mountain Vista Medical Center and the IASIS defendants. I'm going to address the two issues. One, Dr. Berlin, two, the cross-examination. With Dr. Berlin, I submit to the court that Mountain Vista Medical Center is not required by Arizona law to call an expert. The burden of proof is on the plaintiff. As you're well aware, the statutory scheme in Arizona is 122603, 122604. In a medical malpractice case, plaintiff has to call an expert just to maintain the case, to get it past the directed verdict or summary judgment. Then you also have the Arizona case law that says if it's not grossly apparent, the medical negligence allegation to a layperson, then basically what happens is The plaintiff, not the defendant, has to produce evidence to show the jury that there's negligence to support it. So all of this, there is no case law, there are no statutes requiring the defendant to present any evidence. It's plaintiff's burden. We didn't have to, if plaintiff rested, we wouldn't have to present anything.
Well,
Now
I'm sorry.
Go ahead.
Mr. Chegan, Mr. Greisen suggested to us that what was uncontested here was that the MRI was lost or not transmitted, or was not transmitted in a timely fashion. And that's what he posits as sort of the uncontested factual underpinnings that support this expert opinion. And that wasn't the impression I got from reading the briefs. What can you tell us about that?
It's a little bit more factual into the system. And what I'll tell you is this: the images are pushed to the radiology group. The radiology group reads them and then has to do a report. The ER physician also has to then interpret and do what he's going to do. So you've got three parts here, not just the hospital. That's why there are three separate defendants. What happened here, the problem with plaintiff's argument is they stipulated it out. They stipulated that the images that we sent got to the radiologist. And so basically what happens, go ahead.
Got to the Nighthawk or got back?
Got to the Nighthawk, to UST. So it hits their servers, and that's what we're supposed to do, and we made a phone call there. At this point, from that point on, it's then radiology and then ER.
Aren't you supposed to watch for them to come back, though? Isn't that the argument? You need to wait for them, you need to know if there's something out there, look for it?
Absolutely, and that's why, one, there's a call, and two, the IT, there's been a lot of IT testimony here that basically when it hits and it sends and it says received, that is sufficient, more than sufficient evidence that you have through the IT world, it's been received.
But received where?
Received at the radiology group.
At Nighthawk?
At Nighthawk.
But my point is, didn't the expert testify that there should have been a monitoring to look for the report to come back?
The expert, in Judge Johnson, here's the difficulty that I had with Dr. Berlin, and I thought he was our best expert, even though called by plaintiff. The hospital's facing an expert who comes in and says, the right result wasn't reached as far as something happened. So that with the gestalt of things, I say you fell below the standard of care. And then if in cross-examination, when Mountain Vista goes through and says, were the transmission lines appropriate, were the machines appropriate, was the protocol that we used to send it appropriate, then he admits on cross-examination that the hospital administration acted reasonably. So with that is enough questions for the jury to invoke the expert instruction. The expert instruction is, once the plaintiff puts evidence on expert testimony, a jury can accept or reject in whole or in part what Dr. Berlin's saying. All I'd say to you, Judge, is if they say the result wasn't right, we can say our processes were fine, and if they're reasonable, that's the standard of care.
But you didn't say your processes were reasonable. You had no evidence.
Oh, he did.
Saying Dr. Berlin.
Dr. Berlin did.
You're saying, okay, the expert actually said the process. Well,
Yeah, and I think.
the issue that you're contending the expert was unable to put his finger on exactly what it was that was done wrong within the system.
I'm contending that he's offered as a standard of care expert to say what we did was unreasonable. And then during cross-examination, he says what we did is reasonable. Mm-hmm. That's sufficient to go to a jury. And I think that's a sufficient question of fact that, again, the jury instruction comes into effect. They can accept it in whole or in part. And if a jury wants to say, oh, it's a results analysis, fine. If they want to say, well, the hospital did everything reasonable, then fine. I hope that at least answers part of your questions. So at the end, I believe the burden is on the plaintiff. They can call the expert. We don't have to call anybody. I believe the cross-examination was appropriate with Dr. Berlin, and there was more than sufficient evidence to believe.
Is there a case that that explores this distinction between what happens on summary judgment and what happens when you actually put the expert on trial and is cross-examined? Because it is different, isn't it? And this is a great example of it.
Again, I don't have anything that comes directly to mind. There may be some things in our brief. I would still submit to you that when someone has the burden, like in a criminal case, the defendant doesn't have to testify or put on any evidence. The affirmative duty is not on our part, and we can just rest without calling anyone.
Could you, if the plaintiff had moved for summary judgment and put forth the expert report, and the expert wasn't deposed, what result happens then if you don't put up controverting evidence?
I still think it's a fact question for the jury, because what you get into is, what if you have the greatest expert in the world and we don't put on any evidence? And what if they have the worst expert in the world? And all they're saying is, if we have an expert...
Judgment, though.
Right. If they have an expert, they win. And that's not the case. And in this particular case, there was cross-examination of this expert.
Well, I know that.
I'm sorry, Judge. I'll just go on to the next issue with the cross-examination of Ms. Zimmerman. I believe the cross-examination was appropriate. I am going to read, and basically it's an abuse of discretion standard. And in that, plaintiff, in their direct, Mr. Greisen wanted to get into the drug history with his expert on direct. And what Mountain Vista Medical Center's counsel did is, I objected. And we went to the bench, and as soon as we got to the bench, the first thing out of plaintiff's counsel's mouth was to the judge, and I'm reading, this is page 151, line 13. Mr. Greisen, we all know that addiction and methamphetamine is a major part of this case. If you want me to go back and look through everything that's been disclosed, it's a major problem. I'm asking how she, the expert, approaches it in the emergency room. So at that point, over Mountain Vista's objection, plaintiff is affirmatively putting the issue of Karen Savageau's drug use into evidence, and actually asked on page 150, line 20, ask the expert, you're aware of Karen's drug addiction and drug history, and goes on and testifies about how nurses should recognize and treat people with drug addictions. And as that is occurring, so the issue in cross-examination now opened up by the plaintiff is how meth affects patients in ER and how to treat them. She happens to have an article in her file, and I know there's some back and forth in the briefs. I want you, if you can, look at Appendix 1, the deposition of Polly Zimmerman, page 47, line 20, to page 51, line 2, and in that she says, Mr. Checkett, here are my resources that I use for this case. She uses the word resources affirmatively to me, and she lists the article. So at that point, given the scope of her direct and the scope of cross was within that, on an article about meth use in her file, she cites as a resource, she reviewed it, and she actually edited it. And at that point, you see the tenor of my questions were more about the cognitive effects on a patient in the ER. There were two questions that related some other effects, but I believe the cross-examination was appropriate, and if you believe there was error, it was harmless error. With no more questions, I'll yield my time.
Thank you. Mr. Greisen.
Thank you, Your Honor. Let me address some of the specific points brought out by the defendants in this matter. First of all, the expert instruction is always given, but the trial court must first decide if there is competent evidence to allow that issue to go to the jury. That's to prevent jury speculation. When considering that motion, the trial court must follow the Rule 56 standard, and the defendants would have to have expert testimony in that situation that you brought up, Judge Johnson, or the trial judge would dismiss it before trial. It's not disputed. There was no expert for the other side. And it's not disputed that the subject of hospital administration is beyond the knowledge of a lay jury.
Well, Mr. Greisen, isn't what was suggested here that the the hospital did in fact have expert testimony. It was in the form of Dr. Berlin, who conceded on cross-examination that the hospital practices were reasonable.
You can read the four corners of his testimony, and on places that are not important to his opinions, he did concede some particular points. Does the hospital do something right? Yes. Were there some things right? Yes. The issue is not whether some things were right. The issue was whether the standard of care for detecting that X-ray coming back and not letting the patient go until you know it's back was violated. In any medical malpractice case, there are lots of things the defendant does right. That's not the issue. The issue is on the part that forms the prima facie case for the plaintiff. Dr. Berlin said, and to answer your question directly, Judge Winthrop, that bits and pieces of the hospital policy were in place and they were reasonable. But overall, the totality, education, transmission, getting that report back, and the most important thing that he never wavered on was that you have to have a system in place to detect when that report comes back and be sure it gets to the doctor. So you have a fail-safe. You don't miss things. And that's what wasn't proper, according to his testimony. The plaintiff met the burden of proof. As far as expert testimony by Dr. Berlin, defendants must then rebut with competent evidence. And the reason they have to is to prevent jury speculation. The breakdown of the procedure and the failure to detect that the report never got back in a proper manner is what the violation of the standard of care is. To address this issue brought up by the first speaker for the defense, Mr. Murray, first of all, once a motion in limine is made and ruled on, there is not a need for repeated objections. And that's 4 or 5 cases we put in our brief right down the line. We stand firm on that. I had to do the opening statement knowing what the judge had ruled. And I had to do my best to portray my client in the best possible light, knowing that 30 years of methamphetamine abuse was coming in. The second point was that I didn't perform a proper motion in limine. And I refer you to Record on Appeal number 84 and Record on Appeal number 314. And they say the same language. I'll just read you motion in limine number 1. Come now, plaintiff, and request an order excluding any reference by defendants to any alleged sale of drugs or drug use other than the recent use of intravenous methamphetamines prior to 8/12/2007 by plaintiff Karen Savagel. And I think that
Yeah, we can look at.
you can look at
we
that.
can look at the
This
motion.
addresses Judge Thompson's question because it was misrepresented. I had 2 motions in limine, all drug use other than that little period of time before. Yes, Judge Johnson.
Ask you about the proposition that in the causation and damage aspect of the trial, the references to meth could have been substantially curtailed by simply a testimony about what life expectancy is, whatever it is, and you don't need to talk about why it is what it is. But doesn't that leave open the issue that was identified earlier about causation? I mean, a particular symptom or a particular disability that resulted after the incident. Isn't there a fair dispute about whether that particular condition is caused by past or current meth use as opposed to the incident?
Yes, if I could address that, I'll specifically say, first of all, the defense position was all methamphetamine was relevant 30 years before and after the alleged incident. The trial court ruled that everything came in. I do concede, as I did at the trial court, that a small amount of the methamphetamine testimony could come in regarding the period of time before the incident,
Return.
and the causation testimony could have been handled in the same way, which was a very small amount not getting into the 30 years, not getting into the smoking, not getting into all of the things that were covered, and still get the relevant probative testimony and evidence in with far less prejudice to my client. If I had a jury of 8 members of the Arizona Court of Appeals up in my box for 17 days, maybe at the end I'd feel comfortable that you all would know to exclude these things. But that's not what happened here. Everything came in, all of the methamphetamine. Instead of being handled delicately and in a small amount and dealing with the causation, asking, are there other things that could cause this? Or what type of things could also cause this? Without going and burying my client into the picture that they were able to paint. The marginal relevance of it does not substantially outweigh the huge amount of prejudice. I would say that once the motions in limine were decided upon, I had to do my very best to defend it. I followed the rules. I did the motions in limine. I objected where I felt it was absolutely necessary, but it would have been foolish for me to get up 282 times and object every time the methamphetamine came up, because the judge had already set the rules. They were an issue at the time. I would have tried the case completely different if, as you had said, we had a small amount of evidence regarding the actual effect rather than the 30 years of methamphetamine use. In that particular situation, when we came to the end of the trial, I filed the motion that you're familiar with. I wanted the court to instruct the jury that he had decided as a matter of law that everything that Karen had done before she presented to the emergency room could not be considered as her comparative or contributory fault. I wanted him to tell the jury that's a matter of law, and we weren't able to agree. He kept telling us to draft our own instruction. We couldn't agree because I wanted that told to the jury. And finally, Judge Anderson drafted his own and gave it to the jury.
Thank you, counsel.
Thank you.
I appreciate the arguments presented here this morning by all counsel. We will take this matter under advisement and issue a written decision in due course.
Thank you.
We're going to take a recess to set up for the next case. Thank you.